Victims Assist Queensland. Can I start with an acknowledgement of country, which is on the second slide of our PowerPoint? It'll come up, there might be a bit of a lag as that comes up for us. I acknowledge the traditional owners of the land on which we're holding this presentation. In Brisbane, that's the Turrbal and the Yagara people. I pay respects to our elders past, present and emerging, and acknowledge the important role of Aboriginal and Torres Strait Islanders continue to play in our society. As this presentation is being viewed throughout Queensland, I also pay respect to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening to this presentation. I also acknowledge the disproportionately high rates of domestic violence experienced by Aboriginal and Torres Strait Islander peoples and the additional challenges this creates in responding to this issue. A little bit about this series of webinars. This webinar is one of a series being provided by Community Legal Centres Queensland, with funding generously provided by the Queensland State Government's Victims Services Funding Program, Building Capacity 2018 to 2019. This is the last webinar for this year, but we'll be rolling out further webinars and other resources in the new year. On the next slide, there's some important information I'd like to draw your attention to. Please take a minute to read this information about our legal disclaimer and make a note of our content warning and our Keep Safe resources there. Today's presentation will be recorded and it will be available on our website. The PowerPoint is available via your menu toolbar on the right-hand side, and it will also be emailed out and available on our website after the presentation. There's two ways to ask questions about today's webinars. You can press the button that looks like a hand on the toolbar menu screen on the right-hand side, and at the end we'll unmute your microphone so you can ask your question, or you can type your question into the question box and I'll read it to our presenter at question time. Today's presenter, I welcome Julia Morgan from Victims Assist Queensland. Julia is a Community Research and Liaison Officer and has been since 2014. She provides a lot of training and support in this area to government and government-funded services, working with victims of violent crime, including domestic and family violence. I'll hand over to Julia now and let her tell us a little bit more about herself in this webinar, and I'll make a note of any questions that come in and we'll address those at the end. Thank you everyone, enjoy today's webinar. Thanks Julia.
Okay, good morning everybody. As Stephanie has said, my name is Julia Morgan and I work for Victims Assist Queensland. I just want to run through what we're going to cover in this webinar. I am assuming that you as CLCQ officers and legally trained people that you have a lot of assumed knowledge. So I'm not going to cover a lot of the basics that I would normally cover in a general presentation. What I am going to do is explain to you how you can confidently explain our scheme to your clients, how you can help them apply for financial assistance, and importantly, explain the limitations of what's available so that you can build realistic expectations. We really value your help and assistance in helping people apply to our scheme. We also really value your assistance in helping people understand the decisions that we're making and what to do if they disagree. As with any administrative decision by a government department, they are all able to be appealed, and we really value your assistance in explaining that to your clients. So, as I said, I'm not going to go through, VAQ 101. What I am going to give you is the large pieces, the big blocks in a logical order, so that you can all construct a similar story when you're working with your clients and provide a consistent message across the state. So that means I'll cover things like the primary services that we offer, and importantly, the types of assistance that may be granted and the types of assistance that are not considered. I'll also cover things like how we make payments, who we make payments to, and particularities of working with victims of domestic violence. Before I go on, I just want to note that I am not a legally trained person. I am a social worker and I'm employed as a community engagement role. I'm also not a domestic violence expert. My expertise is in victims' rights and explaining how victim assistance works in Queensland. That means I can't answer a lot of technical legal questions, although I can take questions via email and receive answers from our legal assistance officers. Okay, so to start with, who is Victim Assist and what is our purpose? Why are we here in Queensland and what are we hoping to do? Victim Assist has quite a clear purpose that is centred around helping victims recover from the impact of violent crime. We do this by providing financial assistance, by leading and coordinating the victim services sector, and by assisting government and non-government agencies to develop an understanding of and comply with the Charter of Victims' Rights. As many of you will be aware, we introduced a Charter of Victims' Rights last year on 1 July 2017, and as Officers of Community Legal Services Queensland, you do have an obligation to be aware of victims' rights and to help ensure that those rights are adhered to. The rights are published on our website and can be accessed at any time. So just by way of providing you a bit of background as to how much assistance we have provided over the years since 1 December 2009, sorry. That was when our scheme was implemented and we pushed go on providing financial assistance in this way to people of Queensland. Since that time, we've paid over $100 million in financial assistance. Those are actual payments. We've granted $125 million. And I'll explain the difference between a grant and a payment later on in the presentation. In total, that assistance has been paid across 20,000 applications. So you can see that in a relatively short period of time, we've been able to provide a significant amount of assistance to a very large amount of people. Throughout the webinar, I'm going to use 3 acronyms. They are COVA, VOCA, and VOCA 2. These acronyms are used to describe changes in legislation in Queensland. The dates presented on this slide are very important because they affect people's eligibility. As I go through, I'll refer to transitional provisions that are anchored to these particular dates. Okay, so as I said, we primarily provide financial assistance to help victims recover. One of the questions that we get asked all the time is what are the eligibility criteria? The answer, in short, is we don't have a hard and fast checkbox of eligibility, but we do look for 4 things to confirm that a person may be eligible. So these are kind of the 4 things that you look for before you start an application process. So first of all, we're looking for, is it an act of violence? We can only provide financial assistance for acts of violence. That means that it has to have been a crime that is an act or omission constituting a prescribed offence. And under Queensland law, that is an offence committed against the person of someone, including attempting to commit or conspiring to commit. In realistic everyday language, that means that we don't cover property offences. We cover offences against people that are living. It's very clear in our legislation that those limitations exist. So we can't provide financial assistance to someone because their car has been damaged or their house has been broken into. There has to be an offence against a person. The other thing we look at under VOCA is that was this offence committed in Queensland? It doesn't matter how long a victim has lived here. The only thing we're considering is where did the violence happen that caused the injury. For domestic and family violence particularly, and for other forms of violence that can happen over a period of time, such as child abuse, we have to consider what to do about multi-jurisdictional crimes. So a crime that may have begun in Victoria, for example, and then the family relocated to Queensland. With these multi-jurisdictional series, we only cover the offences that actually occurred here and the injuries that directly resulted from those offences. That can be quite tricky when you're working with crimes that cross over changes in legislation. But I'll go over that a little bit more on a future slide. The third criteria we look for is that the act of violence that occurred in Queensland directly resulted in the death or injury of one or more persons, irrespective of where the death or injury happened. The injury component of our scheme is very important, and it's a component that is often overlooked. We require evidence that a person was actually injured by the act of violence. The meaning of injury in our scheme is quite broad, and it's described in Section 27 of the Victims of Crime Assistance Act. And it's worth your time to look up that description and take particular note of the adverse impacts that are described in the Act. These adverse impacts apply to victims of sexual offences, and importantly, they apply to victims of domestic violence. So they expand our scheme to include adverse impacts like an increase in fear or feelings of insecurity, or an adverse impacts on self-worth and perception. So when you're looking at how the act of violence resulted in injury for a person that's a victim of domestic violence, sometimes there are no physical injuries. And when we say mental illness, we mean a diagnosed mental illness. So often the injury we're referring to with these applications are those adverse impacts. It's the sense of violation, the reduction in self-worth, those kinds of things. When we changed our legislation last year, we removed the requirement of a specific medical certificate that we used to have. And at that time, there was a bit of misconception around whether or not we had removed the requirement for any proof of injury. No, we haven't. We do need supporting evidence of injuries. So best practice for people assisting clients to apply is to help them gather that information and put it with the application. While we can obtain some information from police statements and records of occurrence when they've attended a property or a particular place, we can get some information about injuries from court records and sometimes from hospital records. If we have to go through an official MOU process to obtain that information, it will generally slow the application down. So it is a lot more efficient for the applicant to gather that and attach it to their application. The last criteria that we look for is that the crime must be reported. So under old legislation, we required a crime under COVA, a crime needed to be convicted in a district or Supreme Court. We removed that requirement on 1 December 2009. So offences that occur after that date, they don't need a conviction, but they still need to be reported. So with domestic and family violence victims, there are exceptions to who they can report to. So under our Act, it says that violence must be reported to a police officer, or for an act of violence against a special primary victim, a police officer, a counsellor, a psychologist, or a domestic violence service. So a special primary victim can include a victim that is a child or a victim that is a victim of domestic and family violence, someone that has impaired capacity, and a victim of sexual offences, or a victim that is the act of violence has been committed by a person in a position of power and control over them. So for most of your clients in a domestic violence context, they have the choice of who they report to. But we like to make it clear that we encourage reporting to police. We realise that people are not always ready to report at the time the offence occurs, but we encourage them to do that as soon as they are ready. If a person is using a special primary victim option and reporting to a relevant professional, that professional needs to gather the information in a similar way to what police would gather it. So we need to know what happened, to who, where and when. We can provide a template to counselling services or to your own officers to use for this purpose, or they can construct that in the form of a letter. But we need to know those specific things. What happened, to whom, where and when. Those details help us meet the criteria of, is it an act of violence or is it not? And it also, the when helps us decide what transitional provisions we have to take into account. Okay, so the rest of this presentation is going to be anchored to a particular case study. And rather than make one up out of my own head, I'm going to anchor it to a song that was put out by a Logan Van Savage Garden in the 90s. This song was written by Darren Hayes, one of the band members, and it is an autobiographical song of his own experience growing up. Darren was raised in a violent home with an alcoholic father that beat his mother regularly. The family regularly moved to and from motels where mum would get up in the night and flee to a motel for safety. But then when things got hard and she ran out of money, she would usually return home again. I chose this example because it is something that we see every day when we work in domestic and family violence circumstances. This constant cycle of people trying to get away from their violent partners and then having to return for financial reasons is one of the reasons our scheme exists. When we are trying to help a person recover, one of the things we're trying to do is break this cycle of having to go home again. So if we look at this example of the Hayes family, if you were helping a person helping Mrs. Hayes fill out her applications, there are a few things you'd want to check first. The details that we have, we can clearly see that there was an act of violence, that there was an assault. It talks about her having bruises, which would be considered an injury. And that we know that the family came from Logan, so that would be Queensland. What we don't know is whether or not the crime was reported. So that's the first thing you would have to check. You would be asking Mrs. Hayes, did she ever talk to anyone about this violence? Did she talk to a relevant professional? If she went to a doctor, did she actually say it was because someone hit her, or did she provide another reason for her bruises? That's the kind of conversation that you need to have with them to establish whether or not it has been reported. If it hasn't, then Miss Hayes would have to make that report, preferably before she applied to our scheme. So you would help her connect with the Domestic and Family Violence Service, and you would help her, you would explain to them the conversation that they have to have and the details that have to be documented as a special primary victim. So if we assume that this was reported, then Ms. Hayes would meet those 4 key criteria, and we would be able to substantiate that it was worth her time to put an application in. The next thing we have to work out is what category she would apply under. So under our scheme, there are different categories. People can apply as a primary victim, a parent secondary, a related, or a witness. When you're working with domestic and family violence victims, it can be hard to work out what form goes with what person. So I want to go through that during this webinar. Clearly, as the scenario says there were bruises on Mrs. Hayes, we can assume she is a primary victim. That means the act of violence was committed directly against her and she suffered the injury. The children are a little harder to work out. So what we have to work out is, are they going to apply as primary victims or as witnesses? When our assessors do this, we use the Domestic and Family Violence Protection Act. And I would encourage you after this webinar to look up sections 8, 9 and 10. When we're processing and assessing applications, we consider people that have experienced the behaviours described in section 8 and 9, which is the domestic violence that the things we think of when we think of domestic violence. It's the abusive behaviour, the coercive control, the psychological abuse. Those people are primary victims. Secondary victims are covered under section 10. These are people that were exposed to domestic violence, but it was not directly towards them. So it's hard to explain in a webinar, and it's easier for you to just read the 3 sections because they do make it very clear who is who under and who can apply under what criteria. So moving forward, we're going to assume that Miss Hayes and her children are all primary victims. That means that the father directed his abuse towards the mother and the children, and that both the mother and the children have suffered injuries. So when you're filling out your application forms, a lot of the information of that 4 criteria is put on the form. So the application form has a place to write what happened, to who, when and where, and it has a place to write who it was reported to. It doesn't have a place to provide information about injuries, and that is a deliberate thing. That information should be provided by a health practitioner, and so they can give that information in whatever format suits them. They can use the medical certificate that's sitting online under the application form, or they can use a different medical certificate that their own practice has on their computer, or they can use case notes. They can give us copies of practice notes. They can do all sorts of things to verify those injuries, but the supporting information comes from the health practitioner. It doesn't come from the person assisting to make the application or from the victim itself. It has to come from a practitioner. The last thing that we need is information to substantiate expenses. So these things are also attached to an application form. On the application form, you might write down that there's counselling expenses, but you don't give a lot of detail. You attach the treatment plan and the quotes from the person providing the counselling. So it's there's a 2-step process. Part of the information goes on the form, and part of it is gathered from supporting documents. So once we've worked out what to put on the form and what to attach, we need to look at what expenses can be considered. So one of the things I was referring to earlier was about I wanted to help you to build realistic expectations so that your clients were not building their hopes up that we would provide something that we actually couldn't provide. There's a lot of misunderstanding about the scope of expenses that our scheme can cover, and across domestic violence services, there can be a tendency to assume that because one person in the shelter got this expense, I will get it too. That's not the case. Every application is considered on its own merits and worked and assessed on a case-by-case basis. So you can't make an assumption that because another person was provided security expenses that a different victim will also get that. It depends on their individual circumstances. So some of the ones that are potentially easier to work out are the injury expenses. So these are the medical and counselling costs. It's important that these costs they have to be reasonable and they have to logically link back to the injury that resulted from the act of violence. So what I mean by that is we can't necessarily cover every single medical expense that a person may have. We can only cover expenses that have a direct link back to the act of violence and the injury that resulted from it. It's important that you complete the relevant sections of the form and attach the supporting information from the treatment providers. It's also, you don't necessarily have all this information up front at the start. If you aren't quite sure what a person is going to need, you could put the application in and you can add information on. You can send it in later, attach the application number to make sure that we link it to the right application, and we will add it to the file during the assessment time. Best practice, however, is to try and cover as much as you can in the first application to get that process moving. So at the bottom of the expenses section of the form, there's a category that we call other exceptional circumstances. This is covered under section 28 of VOCA, and it is quite confusing. There are some misunderstandings that this is a catch-all for any type of expense related to fleeing domestic violence. No, it's not. It is a category that is for expenses that directly relate back to the act of violence and a person's recovery from those injuries. Remember, our primary purpose is about supporting a person to recover. Not all expenses will be able to be linked back to recovery. So I've given you some examples here of our most commonly asked for exceptional circumstance expenses in a domestic violence context. So if we look back at Miss Hayes, you could write something like, my children and I needed to get away from my partner while he was sleeping to prevent further injuries, sleep in safety and recover. So she wants to claim her hotel expenses, what she had to pay for to go to those hotels. Then a lot of domestic and family violence shelters, if she chose to go to a shelter instead of returning home, a lot of those shelters have fees. If a person is paying rent or mortgage and paying shelter fees, we would consider that an out of the ordinary kind of expense. They're paying twice the amount they would normally pay in living expenses. So we could cover the shelter fees, but we would need some proof that they were paying the rent and the shelter fees. We would need evidence of both, and we would need to know that the rent is being paid by the respondent and not by the aggrieved. Generally speaking, that's a lease agreement, it's a copy of bank statements, or it's a letter from a real estate agent or information from a bank regarding mortgage payments. The other commonly applied for expenses security needs. It's very common for a victim of domestic violence that's now in a new home to still feel unsafe. It's common that they worry that their ex-partner will find them and hurt them again. So a lot of people apply for what we call a duress alarm so that they can contact help very quickly from a secure location within their home. We do need quotes to attach to those expenses. We need to know how much those duress alarms are going to cost, and it has to be a reasonable fee. The other thing is Our scheme is not equipped to pay ongoing monitoring fees for duress alarms or any kind of security. Lastly, there's a section under expenses where you can identify a person's urgent and immediate expenses. It's important to identify why. The form specifies that you have to tell us what expenses are urgent and immediate and why. These expenses may be assessed before the general application, and we use Vocus section 97 to 100 to make this interim assessment. If the general application is later refused, the applicant needs to pay back the monies that are paid under interim. So it's important that they know that there's a possibility that they would have to reimburse us. We are not making a full assessment at this time. We don't have all the information available. We're making an interim assessment using the criteria set out in the Act. The Act also specifies that the amount that can be granted under interim is up to $6,000 of the total amount of assistance available. So in Ms. Hayes' circumstance, it would be reasonable for her to be asking for some urgent and immediate expenses. For example, she could ask us to reimburse her hotel expenses to reduce her financial anxiety and the risk that she will return to the offender again. She might ask us to pay shelter fees to limit the amount of time that she is out of pocket for double rent, or she might ask for us to pay for a specialist medical report. So one of the things that we look at with domestic violence is people have often been victims of repeated violent assaults over a period of time, and they may not have sought medical attention each time those assaults occurred. So people can ask us to pay for an urgent medical assessment to do a full assessment of her total biopsychosocial needs and write up a report that tells us what injuries she has suffered and what she needs to recover. Those reports can be quite expensive, and people can claim them on their form as a medical expense or a report expense, and they can also put it under urgent and immediate, so we can put a grant in place quite quickly. Okay, so we've worked out how all these expenses fit into the application process, but the other question that commonly comes up from applicants is, when am I going to be paid? The short answer is, after an assessment has been completed. We can't make payments before assessment is completed. The minimum requirement is that we complete an interim assessment before a payment is made. In most cases, we complete a general assessment, so a full assessment. If we approve an application, in most cases, lump sum payments like special assistance and loss of earnings are paid directly back to the applicant. Unless the applicant is a child or an adult with impaired capacity, and then under Section 94 of VOCA, we must pay that money to the public trustee. Any money that a person has paid up front, so say, for example, Ms. Hayes' hotel fees, she might have paid those herself, or she may have had a friend pay them for her. If she paid them herself, we would reimburse Ms. Hayes. If she had a friend pay them for her, we would have to reimburse the friend. We must reimburse the person that actually paid the money. We've had a few applications come in that have asked us to pay the money into a solicitor's trust account. We will not pay into a solicitor's trust account under any circumstances. If claiming future expenses, so that kind of covers how we catch them up for their out-of-pocket expenses and how we cover their special assistance. But then there are future things. So they may, for example, Ms. Hayes may be needing to go to see a psychologist once a fortnight for the next 2 years. We don't pay all of those fees up front to Ms. Hayes. What we do is we put a grant in place, and then we pay the psychologist after each visit is attended. So we make the grant, we set aside money, so we put the grant aside, but then we pay the service provider directly. So the service provider at the end of the counselling session would invoice back in Ms. Hayes' name, but back to Victim Assist, and we would make the payment to them. It's important to note that we only pay after a service has been provided. Okay, so the last part I want to cover in relation to this family is how to work out what are we doing with the children's applications. So we know that in Australia approximately 1 million children are affected by domestic violence, and that's a fairly conservative figure by all accounts at the moment. So you can expect Victim Assist commonly receives multiple applications from family groups. It is a very normal process for us to receive applications in a bulk manner. So we'll have an application for a mother and her 3 children. If you think back to what I was saying previously about using the Domestic and Family Violence Protection Act to work out what kind of applications they are. So we may, for example, get a primary application for the aggrieved adult and witness applications for the children, or we may get 2, 3, 4 primary victim applications depending on what the circumstances in that individual family are. It's important to note that young people can apply for financial assistance through our scheme even if their aggrieved parents do not. Not all parents are ready to apply to our scheme, and not all parents are ready to walk away from a violent relationship. We can still provide assistance to their children if they ask us to do so. Generally, in normal circumstances, if a child was applying to our scheme, the form would need to be completed by their parent or guardian. There is an exception under our Act for a child to apply by themselves, provided they are represented by a lawyer, a child over 12, that is. So in the circumstance where you were helping a young person to apply where the aggrieved parent was not applying, you would use that category of the Act, and the child would apply by themselves with the representation of a lawyer. We can also cover the Domestic and Family Violence Act doesn't allow for young people to take out DVOs if they're in a violent intimate partner relationship themselves. That doesn't mean they can't apply to our scheme. They actually can. We don't require people to take out a DVO to be able to access our scheme. We need to substantiate those 4 criteria. So if a young person meets that criteria where they're in an intimate partner relationship that is violent, they can apply even if they're under 18. So when we're looking at the children, we're working out, are they primary or are they witnesses? This is important because primary victims can apply for a lot more expenses than a witness can. This slide outlines who can apply for what. So generally, if it was a child claiming as a primary victim, they would be allowed to claim up to $75,000 in expenses from the time they apply until the time they turn 24. So they have a very large range of expenses that can be applied for. Whereas if the child is applying as a witness because they were exposed to domestic violence using that DFP Act Section 10, they would be able to apply for up to $10,000 of medical, counselling, travel and report expenses only. So you can see it makes a big difference to work out what category these children apply under. For the purpose of this training, I'm going to assume that the Hayes children are applying as primary victims, that their father directed abuse towards both them and their mother. So with that in mind, the application could include things like medical assessments of any physical or psychological injury or physical injuries that the children have. Treatment plans that include recommendations could be lined up with that assessment of injury. We would expect to see a psychosocial assessment that outlines what the child's psychological injuries are and the adverse impacts that they have suffered, including impacts on their learning and development because they are a growing child. We would expect to see one or more treatment plans that include recommendations that were written up by the people that did those assessments. Those kinds of expenses can be applied for under our scheme. We would expect to see cover any expenses to implement the recommendations of the treatment plan, so to pay for whatever it was that the psychologist or the social worker or occupational therapist said the child needed. And we would expect to see age-appropriate exceptional circumstance expenses. So things that were appropriate to their age and their living circumstances, which may include things like a new set of school uniforms if a child has had to change school in the middle of the year. When you're working out the needs of a child, generally I personally like to use this hierarchy of needs pyramid to try and figure out what does this child need to get themselves further up the pyramid and fully recover with an optimal recovery from the act of violence. Okay, so we've got a little bit of time left to cover these last slides and I want to allow time for questions. So that's kind of walked you through the things that we put on the application form. The last part of the webinar is about setting realistic expectations. It's important to note that our financial assistance is limited. We cannot cover all expenses, and we expect that a victim of domestic violence will have other expenses that we cannot pay for. Our Act has a clear instructions regarding its limitations and the categories that we can cover. We expect that a victim of domestic and family violence will find the application process difficult. That is not a slight on them in any way. It is simply because the applications are complex. They have to add a lot of supporting documents. They have to work out a lot of different expenses. And when they're doing that, they're doing it at a time in their life when there are a lot of other things going on. So we would expect that they would need support. And that's why we're providing this webinar today and why we provide training to other violence services so that people can go to different services across the state and receive the same kind of assistance no matter where they go to. It's important that your clients know that it is not just a matter of filling out a form. There are other things that we need. There's supporting information that we need. Incoming applications are checked, processed, and queued for assistance. You would have noted back on one of my early slides, we receive a lot of applications. Processing and assessing applications takes a significant amount of time. If the application is incomplete, that time will be longer because we will have to send a request for information and then we will have to wait a statutory amount of time for that information to be received back again. So helping people get their supporting information together at the start makes the process more efficient. Everybody wants to know how long we mean by applications take time. Currently, our processing time for a general application is 12 months. You or your clients can check the progress of their application throughout that time period by using our application status checker. It's really important, given that 12 months may be passing by, that people update us if they change their address, if they change their banking details, or if their recovery needs change. We can add extra expenses in during that 12-month period. The last things I want to cover is legal expenses. Many people that work in the legal profession are aware that a victim can claim up to $500 for legal fees incurred by the victim engaging a solicitor to assist in applying for assistance. It's important to note that if you are working within a government-funded service, this amount may not be available. You have to look at your own service agreements and what you are funded to provide. If you're already being funded to provide assistance to victims of crime, then you may not be able to claim this $500. If managers of individual services want more information about that, I'm quite happy for you to email me your questions. So, lastly, I just want to summarise that what we've covered today. Our aim is always to assist victims to recover from an act of violence. So everything we do when we're assessing the application, when we're working out what people's expenses are and what we can say yes to and what we have to say no to, is all anchored back to that recovery process. What were their injuries and what do they need to recover? We frequently need assistance from multiple agencies, and the help that you give, I can't express enough how valuable that help is to our service and to victims of crime. As I said, our process is not as easy and straightforward as many people think it is, and your help is highly valued. Our own referral officers will refer people to CLCQ services throughout the state if they're asking for assistance. So you can expect people to be coming to you and saying, Victim Assist told me you can help with your application. Okay, we make those referrals most days and we try to link them to their local service or to a specialist service to meet their needs. I'm more than happy to answer specific questions via email about individual applications that you have. So in the question time after this webinar, I can't answer specific questions about individual applications sitting on your desk or clients you're currently working with. Please put those in an email to me to protect those people's privacy, remembering that this webinar is being recorded. Lastly, I want to remind you that I cannot answer any questions related to the outcome of an assessment process, and I mean I cannot answer them by email either. And I can't answer questions related to hypothetical case scenarios either. Okay. Happy to answer questions relating to real clients about the application process, but it cannot be, will this particular expense be covered or not? That decision can only be made by an assessor. Okay, so that's the end of my webinar, and I've allowed time for you to ask questions if you have them. So I'm going to hand the webinar back to Stephanie now to cover any questions that we may have.
Thanks, Julia. That's been fantastic. We do have a few questions. One question is about the source of funding for compensation. Does it come from the perpetrator at all? Does the Victims Assist or any other agency ever chase a perpetrator for payment or a contribution towards compensation?
Yes, we can ask for a contribution. So our scheme, our Act has a section referring to the Offender Debt Recovery Scheme. That means that if a person is convicted of an offence, and it's important that they must be convicted of an offence, we can ask them to reimburse the special assistance payment only. So the little lump sum that we gave the person at the beginning of their application, when we first assess their application, we can ask for that money back. So that may be an amount of anywhere between $1,000 and $10,000, but the offender must be convicted. There is scope within our scheme if a person is concerned that collecting that money is going to cause the respondent to arc up again. They can let us know and we will take that into consideration, and we may put collecting the debt on hold. So please tell us if you think that's going to be a problem, but our normal process is to recover that special assistance only from the convicted offender. The rest of the financial assistance comes from the good people of Queensland through the Queensland Government.
Thanks very much, Julia. You told us about the time for a claim to be assessed being about 12 months at the moment. Can you give us any idea about the usual timeline for an interim claim?
It varies greatly depending on what their circumstances are and the why. But generally speaking, we're still talking 6 to 12 weeks.
Right.
For reimbursement of that component.
Great. A question about people assisting clients to fill in the forms and do the claims. Does a worker need to be registered or have any specific qualification to provide that assistance?
To assist with the application form, no, they don't. A victim can have their neighbour help them with the application. They can ring up and we can help them on the phone. We recommend that victims that have a lot going on and may have a lot of other legal needs that they have to take care of, we recommend that they go to one of the community legal centres, because we like to link them in with someone that can provide a more wraparound assistance to them. But no, you don't need any specific training to help a person fill out a form.
If I understand correctly, community legal centres are not able to charge the fees where you might contribute to the legal costs of that assistance. Is that right?
As far as I'm aware, that has not changed since last year. So we have looked at this extensively over a period of time, and the service level agreements for Community Legal Centres Queensland prevent you from claiming that $500. Individual, but I don't want to say that hard and fast, because individual services may have different modified service agreements, or they may have a service agreement to assist a particular type of victim, but their service agreement doesn't cover another type of victim. So it really does vary case by case, and we are more than happy to answer questions for managers of particular centres if they would like us to clear that up for them. So for example, a service being funded to provide assistance to Aboriginal and Torres Strait Islander victims may happen to be the only service available for the local person that isn't an Aboriginal or Torres Strait Islander. If they're going to do that, then they may be able to claim the $500 because it's not within the scope of their service agreement.
Right. Thank you. And one last question has come in, and I think this person is thinking about the amount of time that it can take to assess a final application, asking whether it's possible to add extra costs to an application during that period of time, or would the applicant need to submit a new application entirely?
No, you can add anything you like along the way. So just get the application in, but when you add extra expenses, make sure that most of those come in via email. It's really helpful to make sure that the subject line has the victim's full name, and if you have it, the application number, so that we can link those emails to the right application.
And one last question about time limits. Are there any time limits for how far back a claim can go, or in terms of future treatments, how far forward the treatment might be able to be paid for through the compensation?
Okay, so as far as how far back it goes, we prefer applications to be made within 3 years of the act of violence. There is scope under the legislation to apply for an extension of time, and there is a space on the form to write down that. So to say, it's been longer than 3 years, I want to ask for an extension of time, here are my reasons why. But in most circumstances, we prefer to receive the application within 3 years of the act of violence. So if it's been longer, you need to tell us why. Common reasons why. I didn't know about the applications. I didn't know about the financial assistance scheme at the time, or I was a child and nobody helped me do it. Those are two of the most common reasons that people give for taking longer than 3 years. As far as how far forward you can claim an expense, applications can be amended for up to 6 years from the time the first grant is made. So I would not be predicting expenses beyond the 6 years. If the applicant is a child, applications can be amended until the child is 24. So you would have a lot more scope, but we generally don't see expenses that are more than 2 years in advance. And then what people are often doing to get around the time frames that it takes to assess. So you would tell us, you would say, over the next 2 years, this child needs to see a counsellor once a month. And then when 12 months is through, you would actually give us an extra treatment plan and an extra quote predicting their ongoing needs, so that could then be assessed and moved through, so that we did our assessment of that amendment before the original grant actually ran out. So we kind of gather 2 years worth of information, but then we take in new information annually so that we can have got processing time overlapping. I hope that makes sense to people. If it doesn't, email me and I'll give you a more clear answer.
Oh, that's great. Thank you, Julia. And thank you, everyone, for your very thoughtful questions as well. We've had a fantastic response to this webinar. Thank you, everyone, for attending. We're going to send out a survey after the webinar is completed. Please complete that for us. It gives us some feedback about the professional development that you need from us. But on behalf of everyone who's watching and listening now, thank you very much, Julia, for such an informative and engaging session. It's been very useful, I'm sure, to our members. I'm going to end the webinar now, but it will be available on our website along with the PowerPoint slides later today or tomorrow. And if you have any follow-up questions, you're welcome to contact me about those as well. Thank you, everyone.